Hello, my name is Erica and welcome back to Be Inspired by Erica. Hope you're fine. So today I want to talk about meaningful friendships. Friendships are important to us because they help us relate with others. For example, family, cousins, and friends at
Good evening and welcome to the Checkpoint program. This is U24 Television, the National Youth Development. The Checkpoint comes to you every Tuesday, 9 p.m. to 10 p.m. And we are always very privileged to host lawyers who help us to interpret a number of legal questions. In fact, today, our focus is on legal questions arising in the present day times, especially in Uganda. Recently, we concluded elections on both levels, speak about national and local, and we've had a number of other matters arising. But without wasting time, permit me to introduce to you the panel. On my far left, I have Murisa Gideon. Murisa Gideon is a lawyer, and this is his first time on the Checkpoint. You're welcome, sir. Please greet our viewers.
Okay, thank you so much, our viewers. Gideon Murisa is my name, as he has introduced me, and I'm very privileged and happy to be here, and I look forward to having a very successful discussion. Thank you so much.
Next, I have Patience Justin Nachitende, and she's a lawyer. She's welcome on the Checkpoint. This is her other time. She has been here on some other occasions. You're welcome, Patience.
Thank you so much. I'm so glad to be here. I'm Nachitende Patience, and I hope today is going to change a few questions you've been asking yourselves about the law. Thank you.
Thank you very much. And then next to me, I have Omara Douglas. He's a lawyer and he's also a legal assistant from Omara Atubo and the Company Advocates. You're welcome, sir.
Thank you very much, Vianney. Quite pleasure to be here again. And good evening to our esteemed viewers. I am looking forward to talking about several issues that are challenging our democracy.
Thank you very much. In fact, you're going to start us off. What are those aspects that Ugandans should be concerned with that have happened in the recent times?
Okay. Over the last couple of days, Vianney, there's three interconnected crises that have characterized our democratic landscape. The first one being the withdrawal of the election petition by Moses Kasivante. The second one being the recently completed new law year that was characterized by plenty of division. And then also you cannot ignore the talk of the speakership. There's plenty of names that are being fronted, and that is an area that I am looking forward to speaking about.
Thank you very much. And I'm going to go direct to Murisa Gideon, and I'm going to ask you to paint a picture for us. Did Kasivante do proper preparations before filing the petition? In other words, was he justified to file a petition in the first place?
Okay, thank you so much, Councillor Vian. Mr. Robert Kasivante, I feel he was not ready to file a petition in the Supreme Court. That's why he has not been able to sustain it. When you look at the reasons he is giving for withdrawing the petition, it is around money issues, lack of finances. Although he's complaining about the opposition political parties not being behind him, it means he did not do enough work to bring these opposition parties, opposition political parties on table and at least have some like memorandum of understanding to pave a way on how they are going to finance the petition. So I believe he wasn't prepared, although he says he sold most of his property to be able to petition, but still it is not enough explanation. Thank you.
Thank you very much. That raises an important question for me, because if he says opposition have not supported him, we've had leading opposition candidates in 2016.
Yes.
Dr. Besje said he was not going to court anymore, depending or looking at what had happened. In fact, from 2011, what had happened with the first two petitions he filed. And Robert Shagurani also said he was not going to court. So what opposition was he meaning? Why was he expecting support from the very opposition individuals who had said they were not going to court?
I think it was just an insinuation, because when you talk about petition, like in the recent presidential elections, we expected at least NUP, which got the second position, to be a leading petitioner, which did not happen because NUP president, Mr. Robert Chagurani, declared that he won't go to court. So I believe Kasvante Robert went to court by himself. So I believe he's only just tying himself to political parties, because I don't think he even mentioned the names of the political parties he had talked to, or the leaders of those parties. So maybe he believed that when he comes up to petition, maybe these political parties will come on board, which did not happen, and he could not sustain that alone.
Thank you very much. Patience, what did you make of those developments in terms of Kasivante petition and the consequent, withdrawal of the same?
The same. I think in the beginning, when he was petitioning, he had reasons. He said that there was misuse of government resources, like, let me say, cars. And he also said that that the president, how should I say, that the Electoral Commission did not follow its electoral laws according to the way they were lined up. And he also said that there was Mr. Museveni, the current president, he did unlawful acts, let me say, of maybe threatening people and what, and of which there is something we call evidence. I think his evidence was not enough to prove that. So the three, because of course, when he raised the petition, he was taking the Electoral Commission to court, he was taking the president to court, he was taking the Attorney General to court. Those were three different parties. And the three parties, of course, they replied to the petition. And they said that the evidence was not on merit. All the three said so, through the different representatives that came up. Because for the NRM, it was Mr. Karujiri who came out for it, and for the EC it was Mr. Tashovia, and for the Attorney General it was the Deputy Attorney General that came up. So when you look at his evidence, it was not what? It was not weighable to that, and even him changing his mind to withdraw. Of course, remember there, after, what happens after you petition? These people reply. What does the court decide? After the court decides, what do you do? So when he looked at maybe the damages he had to award those three parties, he could not what? handle. And yet, again, even when he withdraws, he's going to award the same damages. So I believe he was not guided by maybe his lawyers that came up for him before he went for the petition. So he was not ready enough to petition for that. Yes, in court.
Thank you very much. We are streaming live on YouTube. You could go to YouTube and then type in U24 Television. You'll find the channel. You'll be able to follow U24 Television, subscribe, and you'll be getting updates on whenever U24 Television goes live. But this checkpoint is live, and please send your comments on YouTube. We shall be able to receive them. We're also live on TikTok. You could send comments on X. We'll be able to receive all those comments. And I want to go back to Douglas to tell us, Kanyehamba once stated that it is important to petition. Even when you are not sure whether court is going to decide in your favor, that a presidential petition should be filed. I think in his opinion, he thought there should be a chance for our jurisprudence to grow. So now that Kasibante has withdrawn, what next?
Thank you again, Vianney. You see, the Presidential Elections Act and established jurisprudence provides for instances where you're supposed to withdraw a petition. So you cannot just file a matter in court and then choose to withdraw the next day without any kind of consequence. So in this particular scenario, court has to sit down and hear the withdrawal application. The concerned council have to submit on this application, and then court has to make a ruling. So it is not a question of where you walk into your neighbor's household and engage the occupants and then walk out without any form of consequence. So the whole point is this procedure element is meant to safeguard against abuse of petition processes. So in an instance where this withdrawal is successful, a couple of things are going to happen. The very first one is it's going to put a formal end to the election that was challenged by Mr. Kasibante. So the incumbent, that is Mr. Yoweri Kaguta Museveni, is going to be declared the winner with over 7 million votes. Secondly, the issue of costs. It is upon, obviously, court's discretion to award court costs, but in this particular instance, well, courts could say, Kasibante, you're going to bear the costs. You're going to refund the money that the opposite counsel used to litigate. Or court could decide to make the parties bear their own costs. So the other outcome would be that the co-respondents, that is the Electoral Commission, would be relieved from the duty of participating in these proceedings any further. So those are some of the things that would happen in this particular instance. So once the withdrawal is successful, it's going to put an end to the proceedings.
Douglas, I want to pick your mind. Suppose you are a judge of the Supreme Court and the petition was presented to you and you participated in the election we had last month. Would you allow or dismiss the petition?
Well, depending on the reasons for withdrawal. If you look at Kasibante...
I wanted to leave the withdrawal, the main petition. Suppose it proceeded on its merit and it is time to decide. You're part of the panel of the justices of the Supreme Court. What would be your position?
Well, again, I would assess the evidence that has been advanced by both parties. In his original petition, Kasibante brings about certain allegations. One of them being there is over 15,000 polling stations that were not properly gazetted, and the Electoral Commission went ahead and relied on results from these polling stations. So if I looked into the evidence advanced by Kasiba and found out it is lacking, then I would lean towards the side of allowing withdrawal of the application of the petition. Sorry.
Thank you very much. And I'm going to Marisa. I'm going to now the new year. The judiciary has commenced its year, but we've seen friction between the judiciary and the lawyers. In other words, the bench versus the bar. The judiciary, as it was having its function for opening the new lawyer, the Uganda Law Society was also having a separate function at its offices. They accuse the judiciary of undermining the bar. The judiciary accuses the bar of undermining the judiciary. Why are we at that stage?
Thank you so much, Mr. Moderator. I think everybody knows the judicial new legal year 2026 started with a lot of controversy, especially between the bench and the bar, between the judges and the lawyers, the advocates. Of course, what is bringing all that, I think, is in a simple language, it is just not understanding each other or lack of respect for each side. Like you have stated it, the bench is not respecting the bar, and at some extent, I believe the bar is also not respecting the bench. For example, when the judicial, legal year 2026, or when the function was being held, Uganda Law Society decided to hold a separate function, meaning that one shows that there was no collaboration between the bench and the bar. Two, Uganda Law Society under the president, Mr. Isaac Asemakade, his vice, and the other members also even had a press conference, I believe, and they gave reasons to why they were not part of the function that was conducted by the judiciary. I believe it should be sorted out because it is going out of hand, and it's the comment that was given by Honorable Chief Justice Flavian Zaija also to some extent is like was attacking, was trying to be defensive. The major problem is that...
Which comment was that?
He was, I think, talking about the social media. Like the lawyers and the public are using social media to demean the judges, of which, according to him, is not good. But again, the lawyers are saying no. Judges can as well be assessed. They are human beings. So when they do something wrong, they can be talked about. Because these lawyers are not being listened to before the bench. I think they are resorting to social media to express themselves. That's where the judges, I think, can listen to them. And I believe the judges are getting that because they are starting to respond, because the fire coming from social media is raising all that. So there is a need to bridge that gap so that the bench and the bar are at par.
On the question of social media, as we speak now, Malema is in jail.
Yes.
Because he made some comments on social media about the Chief Justice.
Yes.
And some people have argued that it is not right to apply the law selectively. That there are other people, individuals, some of them in government, who also use social media either to abuse some individuals or what have you. But nothing happens to them. While some young men have already been convicted, others are serving sentence, and the current victim being Malema Birizi. So, are you saying the judiciary fears criticism, or it is just self-preservation?
To some extent, I can say the judiciary, to some extent, is fearing criticism, but it should not be the point, because there is what we call positive criticism. Through positive criticism, you can be able to change. For the case of Malema Birizi, I may not repeat the statements he uttered out here because they are over the social media. But I believe, you see, some of these things are facts. However, they are facts that are supposed to be reserved. So, I don't know, maybe it's because of anxiety or what, I don't know how I can term it, but people have closed red line somewhere. Because even when you have facts about someone, especially the health people know that, you can be having a lot of facts about someone, but it's not good to put them in public, especially using social media. There is an English statement that says, "Show me the man and I show you the law." So on this, coming to the issue of Mabirizi, why is in prison now, and maybe some other people you're talking about are outside, is that maybe the way he blot out the information was not decent enough before the judiciary. Thank you.
Patience, do you agree?
There is something called legitimate criticism. Under legitimate criticism, this is where someone can get their, how should I say, comment from the public positively, and they're able to change. Then there is something else, the opposite of it. That is what he used. So when you go through the videos he posted on his page and you listen to them, you pick out a lot of things, the way he said it. And there is I think what caused all that is that paper he had that had, there was appointment of Chief Justice Flavian Zeija. Then down he writes a recipe for disaster. That was a novel I did in 2014 in my senior one. That novel has, if you look at it, it has a lot of things, a lot of stories that don't even match the Chief Justice that was appointed. So when he brought out all these ideas, it was disrespectful to both the Chief Justice and also Justice Sekana Musa. And that's why he was charged with those 4 counts under the Computer Misuse Act, because the way he brought out the information, whatever he said, you know, it's you can say yes, someone is corrupt, someone is this, but then you say they sold out their property to get that position. Were you there when they're selling their property? Did they call you and say, come and I sell the property as you're seeing, then I get the place? No, you are not there. So some facts, if they are like hearsay evidence, you are not there on ground. So if you're not there, please don't use what you heard from people, because at the end of the day, it's Malema Birizi inside. It's not the other people who gave him the what? The information.
Douglas, there is a decision where Charles Onyango and Andrew Mwenda published a story, and the government thought that story was false. They were charged, and they challenged that constitutionally. The court, the Constitutional Court, definitely gave us a good understanding of freedom of speech.
Very well.
saying that if you're a government official, you should develop a thick skin.
Very well.
You should be able to stand criticism.
Yes.
Are we justified to say that indeed the criticism being levied against the judiciary on social media is part of the wider freedom of speech?
I would agree with the decision that was made in that particular case. You see, criticism of judicial officers is heavily protected under the Constitution. As a judicial officer, you wield a lot of power. So obviously you're subject to criticism from the public. So when you come into this office, you've not come for your ego to be massaged. What freedom of speech has done, most especially with social media, is it has enabled the general public, not just lawyers, to participate in legal discourse. So someone is free to criticize the decisions of a judicial officer. Someone is free to question the reasoning of a judicial officer, and so on and so forth. But I feel like the prosecution and detention of Mr. Male Mabilizi is a bit excessive. You see, it is, yes, the charge sheet says there is 4 counts, 2 of hate speech and the other of, what's the other?
There are 4 counts, 2 of malicious information, then 2 of hate speech.
Yes. So these are offenses that one is supposed to obtain bail for. So if you remind someone over such offenses that are not even that capital, then in a way or two you're infringing on their rights of liberty.
The Constitution says the right you're speaking about, freedom of speech, is not absolute.
True.
It can be limited. True. And in fact, also courts have said they can be limited. But the test is to the extent as to what is demonstrably justifiable in a free and democratic society. So if you were the Chief Justice today, what would you do to the attacks, social media attacks, being directed to judicial officers?
First of all, I would advocate for proper framing of what constitutes harassment of a judicial officer. I would try to restructure the laws to make it clear that certain statements do infringe on the rights of these judicial officers. If you can do that, then you're going to control what is, being put on social media.
I've seen the president of Uganda Law Society, who is currently in exile, saying the public, we have a right to abuse public officials. Do we have such a right?
I don't agree with that. You see, there is abusing and then there is legitimately criticizing someone's work. If it goes beyond criticizing a judicial officer's work and you start abusing their person, them in their, individual capacity, then that is a bit extreme. So, yeah.
Thank you very much. And on that point, I'm going to go to Marisa, and I'm going to change now to the current setup that we have got from the voting. People are already vying for the position of the Speaker and the Deputy Speaker. We've had news that the NRM has already ring-fenced those 2 positions for some individuals. And some people are saying, perhaps this is a time where we have no opposition in Uganda. We have seen Professor Yusuf Nsibambi leading a delegation of opposition members to visit the president. And others are saying it might be very, very difficult for opposition to be productive in the next parliament. First, I want to pick from you, is NRM legally justified to ring-fence the position of the Speaker? Or every member is free to contest on those positions, and therefore the decision of NRM does not bind anyone?
Okay, thank you so much, Mr. Vian. You see, politically, NRM is right to ring fence the position of the speaker and the deputy speaker, because they have interest in that and they have a lot of business to do for the government in power in that house. So politically, what NRM SEC did was right, but constitutionally they are wrong. Reason being, the constitution is clear, and I think Parliament's Act is also clear on that. Every member of Parliament has a right, actually they have equal rights to compete for those two positions, the Speaker and Deputy Speaker. What I see is that after NRM SEC deciding or ring fencing that the two positions, they are disabling the other NRM MPs, because the position of NRM SEC does not affect the opposition members of Parliament. They can still vie for those posts because the law allows them. Only that the MPs on NRM side are now tied. They have no option, and considering the political situation in Uganda, especially in NRM, when the SEC decides, it means the big man has decided. So whoever comes up to oppose that is will be branded as a rebel MP, like the likes of Honorable Theodore Thechkubo, Honorable Tinka Simire Barnabas, and you know what happened to them. So actually, they have already imposed fear within the NRM MPs who were having the interest of contesting for those two positions. And they have nothing to do now. Unfortunately, they have nothing to do, because when they come up, they will be like opposing the big man. And the decision of the SEC is the decision of the big man.
You want to?
Yes, I want to highlight the fact that, again, the decision of the central, the SEC, executive, yes, is non-binding on the members of Parliament. Remember, a Speaker of Parliament is supposed to be voted for by the members of Parliament. So if it comes to a situation where now NRM is starting to make these decisions and influencing them in Parliament, then there is a problem. So I would like to believe, like what Honorable Norbert Mao said recently, he made it very clear. Every member of Parliament is entitled to this position for as long as they qualify. He himself, I hear rumors in corners that he's hinting at, vying for this position. So I don't think it is legal for NRM to ring fence these positions. I feel like it should be left to the MPs to decide who the Speaker and Deputy Speaker should be.
You highlighted that politically they are right, because you seem to suggest that you cannot leave the position of Speaker to political chance. If you do not ring fence it, you may not know who is going to take it, and that might be it might affect your interests adversely in the Parliament. What can we say is the effect of having, for example, Anita Among back as a Speaker? What did she achieve in the last Parliament that should reward her to again become the Speaker?
Thank you so much. You see, to begin with, Honorable Anita Among previously was an opposition person, was in FDC. So, as I talk now, she's NRM. Even her deputy, Honorable Thomas Taeba, was FDC. But now they are NRM MPs. They have worked tirelessly, actually, to make sure that His Excellency President Yoweri Kaguta Museveni gets the 70% and above which he got in the just concluded presidential elections. And two, those two have done a lot to bring more opposition MPs to NRM. And that one works for President Museveni. So they are big guns in NRM. And therefore, ring fencing the two positions, the speaker and deputy speaker, for them is automatically rewarding them for what they have done.
Thank you very much. I'm going to Patience to pick her view on that. Do you think it is legally justifiable that that position should be ring fenced?
I think it's going to cause a lot of criticisms from the, you see, of recent, the NRM youth groups were arguing, well, like, everyone has a right to come up in the parliament as a speaker or what. So it is going to leave them out, the youth, because remember, they have that NRM, then they have the NRM youth members. So leaving them out, it's going to kill the constitutional right of anyone in the parliament, any member of parliament standing for that position. And then the other one is that it's like as if the one party wants to take over the whole parliament, because remember, it has the biggest number of members in the parliament. So if it ring fences the deputy speaker and the speaker's position, it's like as if it's reducing the number of opposition members in the parliament, which will make our parliament one-sided instead of being two-sided.
Thank you very much. Douglas, yes, people are concerned about the next parliament.
Yes.
We shall not have the likes of Semu Junganda, Medad Segona, Matthias Mpuga, and many, many others, including Theodore Sechkubo.
Yes.
And people have suggested the opposition will be almost nowhere in that parliament. What is your view on the next house? And I want also to pick from what has been suggested, that because the speaker and deputy speaker work tirelessly to ensure that the president gets a higher percentage, is that a ground for which we should renew their speakership?
I don't believe so. But most importantly, these people that have been phased out of parliament, the likes of the Seki Kubos, the Semujungandas, have left very huge shoes for the new, guns to fill. So there is quite a very big challenge for the new people that are coming in the sense that these are MPs that have been outspoken. They say it as it is. So they have a task of replicating the same. They're coming into parliament, but there's so many things that are happening that need addressing. You have situations where MPs that belong to the opposition are being detained and abducted and not produced in court, denied bail, and so on and so forth. These are things the new MPs that are coming in are going to have to deal with. So you have situations where public officers are misusing funds and the ruling party MPs are looking the other side. So it is incumbent on them to actually immerse themselves in investigations through the Public Accounts Committee, to bring some sort of semblance of sanity in public offices. So yeah, they have quite a task ahead of them.
Thank you very much. Ladies and gentlemen, I'm going to get your final remarks because time is not our best ally. I'm going to pick your final remarks on these subjects as we come to a conclusion. Over to you, Murisa.
I would say in Uganda's situation, especially the political situation, I think there's no leveled ground. Conclusively, there's no leveled ground. Therefore, in the future, I propose.
What do you mean when you say there is no leveled ground?
For all political players, especially the government and the opposition, because when you see how the opposition leaders and their supporters have been treated in some areas, is inhuman. And I believe there are very many Ugandans who are in the prisons for no cause. In other words, they were taken to prison when they were innocent. And that one has even crippled the opposition leaders. However, I, to some extent, blame the opposition leaders. I am trying to believe, like the statement once the President Museveni made, that to some extent we shall not have opposition in Uganda. I'm trying to believe that because I see opposition leaders opposing their fellow leaders. And when the opposition leaders fight, of course, it is the government winning. Because that one, I can give a few examples of whereby we have been having vocal members of parliament who are on the side of opposition, but they have been replaced by, of course, the other opposition leaders, but which we see that they will not have more, they will not have an impact compared to these ones that have been removed. And two, in the next election, I think demilitarization of elections, using military to intimidate. Actually, when we talk about intimidation, people think it's about beating people, it's about arresting them. No. There are people who don't even want to look at the military uniform. Just me looking at the army moving around, it's enough to make them even remain at home and not to go to the polling stations to cast their votes. So I believe in the next election, it should be rectified. And I think the government should reduce on the energy or on the power it is using, especially in handling the citizens who are believing in opposition.
Okay, thank you very much. Thank you very much, Lisa. Over to you, Patience.
Yes. Basing on what we have heard today, when we look at the matter of the election petition for Mr. Moses Kasibant of the National Peasants Party, we look at the way he entered petition, then he's now entering into withdrawal for the petition, and then he has, there are consequences for that, there are damages he has to, there is evidence he has to confirm that, yeah, it is real evidence, so he has a lot of things to do. For any member who is coming out to petition against maybe the ruling party or the government, you need to prepare yourself. You need to have evidence that is going to show that, yeah, I'm going to win the case. And even it's not about a win-win, but it's not about a win-lose, but you need to also look at after the petition what is going to happen. And then secondly, for the matter of the bench and the bar, this is like a personal experience. For example, you may come to court and I'm the judge and you bully me in my court. Of course, I'll have to bully you back. And if maybe it's the other way around, of course, I have to do the other thing. So maybe these people of the bar were misled by their leader, I don't know. But the effort they are using, they boycotted the judicial conference, the one for the 3 days. And then they went for the new lawyer after those 3 days. So when you look at how they behaved, these are all under the judiciary. These are the people that we are going to take 2 cases, and our cases are going to sleep on table. And then the other thing is for the NRM's sake, I think it's going to affect the opposition parties, because the opposition is the one that sits in most of those COSASA, those that deal in maybe accountability, scrutiny. So how can maybe like 30 people sit in that opposition and yet the rest of the biggest parties under the what? Under the parliament, under the ruling party. So we need to also look at that. And then for the NRM sake, they also said that members of parliament, those members of the NRM that feel aggrieved, they can stand independently. They did not refuse anyone to stand independently. For that, they said. So, basing on all that, that's what I had for you today. Thank you.
Thank you very much. Isn't that a trick that they stand independently? What is the chance? They will go through. It's a trap. Over to you, Douglas. Your final remarks.
Yes. Vianney, our legal landscape in 2026 is worrying. There is obviously a fracture in the relationship between the bar and the bench. At the new lawyer that was conducted by the judiciary, the Chief Justice, Dr. Flavian Nzeja, in his remarks was pointing towards the achievements of the judiciary from the year 2025, where he highlighted improvement in case management and completion. He also highlighted the fact that the judiciary's budget has been increased, which is a good thing. So he has more of been pointing towards the efficiency of the judiciary. On the other hand, the Uganda Law Society, through its vice president, when he was making his remarks, he was more of emphasizing the fact that the same institutions that are supposed to protect the rights of Ugandans, that is the security organs, are instead violating these very rights. So these are two different positions. One is fighting for human rights protection. The other one is showing how efficient the judiciary is. So in my humble view, I feel like there needs to be a dialogue. The vice president came out and said, look, he wrote to the judiciary and said, we need to sit down and resolve some of these issues. So I would want to see them sit down and resolve, because it is for the good of the general public and the society at large. I also feel like the ruling organ should stay away from the activities of certain organs of the government, certain elements of the government, that is, certain arms of the government, that is the legislature. I don't find it necessary for the NRM CEC to, intervene in the position of the speaker. Let the MPs choose who they want to, have as their speaker, and so on and so forth. So, again, the rift in the relationship between the bar and the bench causes a major concern, because the same institutions that are meant to check powers are themselves under a lot of pressure, which isn't a very good look on our judicial system. Thank you.
Thank you very much, sir. And thank you very much. This evening, we were discussing the present legal questions in Uganda, and I was very privileged to have a panel with Murisa Gideon, who is a lawyer. I had Patience Nachitende, who is a lawyer. I had Douglas Omara, he's a lawyer. He's also a legal assistant at Omara Atubo and Company Advocates. And me, I'm John Viana Yevare, who has been hosting you this evening. The Checkpoint will come to you every Tuesday, 9 p.m. to 10 p.m. here on U24 television. And we shall see you next week on Tuesday. Next is U24 Cinema. Have a good night.